The Saskatchewan Court of Appeal has ruled the challenge to the province's school pronoun law can proceed. Last year, Saskatchewan invoked the notwithstanding clause for Bill 137, requiring children under the age of 16 to have parental consent to change their names or pronouns at schools. A legal challenge by an advocacy group was granted, which halted the immediate implementation of the bill. Today, the province's highest court sided with the lower court, saying the legal challenge may proceed. Joining me now is Cee Strauss, senior staff lawyer at the Women's Legal Education and Action Fund. Cee, thanks so much for joining us. What does it mean in this case when the province used the notwithstanding clause for this bill?
It means that the province that despite the fact that the bill might violate people's rights, in this case trans and non-binary youth's rights to security of the person and equality rights, the law can remain in force so that the harms will still exist. The youth are having their rights violated, but that doesn't affect the impact of the law. It can't be struck down as unconstitutional because of the notwithstanding clause.
So now what does today's ruling mean for the bill, and how will it proceed through the courts?
Right. Today's decision is a real victory for the rights of trans and non-binary youth and for the rights of the most marginalized in Canada generally. It is, though, one small step in the process. But what today's decision means that a court has jurisdiction to declare that a law violates people's rights. That will not mean that the law can then get struck down because the notwithstanding clause is still in effect. But it is Leaf argues, and many others have argued, that it is still extremely important for a judge to be able to declare that the law violates rights. So Leaf argues that that's the case because that will recognize trans and non-binary youth's experiences of discrimination in the courts, which will be extremely important in the face of trans youths not being able to be held to be credible narrators of their own experience. And it will also really help the general public, because the idea with the notwithstanding clause is that if it's passed, the idea is that it'll be sorted out at the ballot box. If the public disapproves of the government's use of the clause, it can go ahead and vote that government out at the next election. But in order to decide how to vote, the public should have access to a rigorous analysis of the law's impact on rights. So today, the court decided that the government can have access to that rigorous analysis of the law's impact on rights. The question then now will be whether at the lower court in Saskatchewan, the judge decides to make that declaration or not. That's still not clear. And
from the perspective of yourself and those working with Leaf, what are the potential impacts here of this bill on students and schools?
Well, and it's already enforced. The law isn't, it's not a bill anymore. It's a law. It was passed in September 2023, I believe, and it's in force. So it's already impacting people. And the impact is, increased bullying and risk for trans and non-binary youth for their mental health and ultimately for their desire to live, because not having your pronouns and your name respected in school is an extremely traumatizing for people, and it does lead to them basically having much lower self-esteem. Like when your identity is not validated, then your mental health really severely declines. So there's a lot of evidence on the side of this law being traumatizing and harmful, which is why the judge put an injunction on it in the first place.
Cee Strauss is a senior staff lawyer at the Women's Legal Education and Action Fund. Cee, greatly appreciate your time today. Thanks so much for CTV News Channel.
Thanks for having me.